morning, Ms. Park. Could you please introduce yourself to the jury?
My name is Annie Park.
Why are you here today, Mrs. Park?
Well, I'm here because my daughter, Sydney, she was shot.
All right, I'm going to talk about that in a little bit, but first I want to talk about your family. Could you tell us about what your family was like before you lost your daughter?
Well, Lee and I, we met in college after I was in the Navy for 4 years. We had Sydney about 9 years into our marriage. At first, I wasn't sure if I wanted a child, but as soon as I held Sydney in my arms, it was like she was a miracle, and I would never go back.
Mrs. Park, I want to show you a picture of Sydney. Is that okay with you? Your Honor, could I approach Mrs. Park who plans to live at 17?
You don't need to ask.
Oh, my apologies, sir. Excuse me. Show the opposing counsel plans to exhibit 17. Mrs. Park, I'm handing you plans to exhibit 17. Could you tell us what that is?
This is a photo of my daughter, Sydney.
Is it a fair and accurate depiction of your daughter before she died?
Yes.
Has it changed or altered in any way?
No.
Your Honor, plaintiff offers plaintiffs to exhibit 17 into evidence.
Any objection?
Your Honor. This is more prejudicial than it is probative, according to Rule 403.
Response?
Your Honor, in order to exclude evidence through Rule 403, they must show that this prejudice is unfair prejudice. Not only that, but that the prejudice is substantially outweighing the probative effect. This picture doesn't show Sydney when she died or the day of her death. It just shows how she looked when she was 11. There's no unfair prejudice involved. We just want the jury to get an idea of what Sydney looks like.
Response?
Yes, Your Honor. For the plaintiff to show this picture of Sydney would have an unfair prejudicial value, as it contains no probative value for the jury to see. Now, seeing Sydney Park, a picture of her, might evoke an emotional response from the jury and inflame their passions, where it contains relatively little probative value.
Yeah. What's the probative value here?
Your Honor, we just want the jury to get an idea of what Sydney used to look like and to get to know Sydney better. The
Right,
jury,
but for what element of your burden is that probative value?
Your Honor, we're not using it to prove anything right now. We just want the
So if
jury.
you're not using it to prove anything, what's its probative value?
Your Honor, its probative value is helping the jury to get to know the case better. We want the jury to have a better background of what the Park family was like in order to understand the evidence better.
Response?
Again, Your Honor, if this photo is not being submitted to the jury to prove anything, that its probative, that its prejudicial effect would outweigh any probative value that it has.
Your
Yeah,
Honor.
you gave away the game when you said you weren't using it to prove anything. Did you say any objection?
Yes, Your Honor. Could I get that back from Mrs. Park?
You may.
Mrs. Park, could you tell us what it was like to raise Sydney?
I know every parent must say this, but Sydney, she was such a joy to have in my life. She was always smiling and laughing. She was just curious about everything going on.
All right, I want to talk now about somebody named Jessie Duran. Do you know who that girl is?
Yes, Jessie was my next door neighbor's child, and Jessie and Sydney played a lot.
What kind of things did they play with each other?
Jessie and Sydney like to play a lot of video games and cops and robbers.
And I want to talk now about a gun. Did you keep a gun in your home, Mrs. Park?
Yes, Lee and I kept a gun in our home. We bought it in 2010 after someone broke into our house. My husband, he travels a lot, so I didn't feel safe in the house, just me and Sydney. I bought it to protect us in case something else happened.
Could you tell us how you stored this gun?
We stored the gun in a Galucci safe in our bedroom. We chose a Galucci safe because it was sturdy, and I read all these reviews online saying that it was one of the best safes. We had the ammunition stored in the garage as well, and it was a revolver that we owned.
How did you get into this safe? How was it locked?
The combination.
Where did you keep the combination to this safe?
The combination was in our office on an unlabeled piece of paper. It was in a file labeled for emergencies only.
Did your daughter Sydney ever find out that you owned a gun in your home?
She did. One day before the shooting, she pulled me aside and asked where we kept the gun. Of course, I said that she didn't need to know that. Guns were dangerous. She walked off, and that's when I noticed Jessie Duran outside of our bedroom. listening to our conversation
Now, when did this occur?
the day before the shooting, August 17th.
What did you do after Sydney asked about your gun?
Well, immediately I went and I looked in the safe and I checked that the gun was unloaded and that the bullets weren't there. I closed the safe and made sure it was locked.
All right, I know this may be hard for you, but I actually want to move on and talk now about the day that your daughter died. Could you tell us how that morning began for you on August 15th?
Woke up that morning and me and Sydney got ready for the day. We were in the kitchen singing the Jonas Brothers. She loved to sing the Jonas Brothers. I hated them, but we got ready and we were making breakfast, and then I went to work at about 9:15.
When you went to work, did you leave somebody to supervise Sydney?
No, Sydney and Jesse were alone that day. I had the neighbor across the road. He said that he would check in on them sporadically.
When you were at work, could you tell us what happened when you first found out that something had happened at your home?
I don't really remember what I was doing, who I was talking to. I just got a phone call from a police officer. He said I had to come home straight away. I kept asking him why, but he wouldn't tell me. And I got in my car, and I don't remember how I got home. I remember pulling into the street and seeing all the police cars. My heart just dropped.
What happened when you got out of your car?
I went up to a police officer and asked what happened. He said he couldn't tell me. I said, "This is my house. This is my daughter. You need to tell me what happened." And he took me inside. I saw my little girl under a sheet, a white sheet. I couldn't believe what had happened.
What did you do after you saw your daughter on the ground?
Just started sobbing. Losing a child isn't something anyone should ever have to go through. I could never go back into that house after that day.
No further questions, Your Honor.
All right, cross-examination.
Yes. Permission to proceed? Ms. Parker, I understand this may be difficult for you, but I'd just like to ask you some questions about some things you mentioned on direct examination. If you need a moment, feel free to take it at any time. I'd like to talk to you about the gun that you kept in your home. In early 2010, your house was broken into,
Yes, it was.
and you were scared after that.
Yeah,
So you bought a gun for self-protection,
to protect me and Sydney, yes.
and you bought a safe for that gun,
We bought a Gucci safe.
and you kept this safe in your bedroom.
Yes,
And as part, the safe itself was locked,
yes,
but Sydney had access to the room that the safe was in.
our bedroom, but it wasn't really an area she went into. It was me and Lee's private space.
Well, Ms. Park, you didn't lock your bedroom door,
No,
and Sydney could enter this room whenever she pleased.
yes,
The combination to this safe was stored in your office and guest bedroom, right?
yes. It was in our file cabinet on an unlabeled piece of paper in a file labeled "for emergencies only."
Now, this combination was composed of your family members' birth dates.
Not exactly. It was a representation of those dates.
So your family members' birth dates were contained in the combination, right, Ms. Parker?
Not the whole thing. The combination was only 3 numbers.
Well, this combination, as you mentioned, it was stored in a filing cabinet in that room,
It's where we kept all of our important documents.
and it was stored in a folder in that filing cabinet
Yes,
marked "for emergencies only," right?
like I said.
Now, this drawer that the combination was in was unlocked,
Yes,
and Sydney had access to the room that the filing cabinet was in, didn't she?
She went in there to use the computer sometimes.
Ms. Parker, in May of 2010, you even found Sydney going through that drawer in the filing cabinet.
I did. I was really shocked that she was doing that. She knew she wasn't meant to go in there, and I asked her what had happened. She said Jesse told her to go into it to get something back for him.
So, just to reiterate for the jury, Ms. Parker, you never found Jesse Duran going through that filing cabinet drawer, did
No,
you?
I would have been more shocked if I found Jesse in our private files.
Well, Mrs. Parker, you found Sydney going through that drawer.
Yes, that's what I said.
And when you confronted her about this, she said, I know you keep all of the important papers in there.
She immediately started crying after I talked to her about it.
Well, Ms. Parker, if I could just redirect you back to my question. She did say to you, I know that's where you keep all of the important stuff.
I'm sorry, yes, that is what she said.
After this event, you never put a lock on that drawer.
No,
You never moved the location of the combination.
no,
The combination was in the same place on August 18th, 2010. Isn't that right?
well, when I caught her going through the file cabinet, I didn't see her in that file specifically.
But, Ms. Parker, the combination was in the same place on the date of the incident, right?
Again, I didn't see her going into that file. I didn't think that's what she was looking for or that it needed to be moved. She told me she was looking for something else.
Ms. Parker, later in the year, Sydney asked you about the gun that you kept in your home, correct?
She did.
And this was on August 17th, the day before the incident?
It was.
Now, again, Mrs. Park, just to be clear for the jury, Jesse Duran never asked you where you kept a gun in your home, did she?
She didn't. But she was standing there when I had that conversation with Sydney.
Mrs. Park, Sydney asked you where you kept the gun.
Yes,
Of course, you refused to tell her.
of course.
As Sydney walked away from that conversation, you heard her say, whatever, I'm sure it's in the bedroom.
She said that to Jesse as she left my bedroom.
So, Miss Park, the day after you found out that your daughter knew where you kept a gun in your home, you allowed her to stay home alone?
Yes.
Thank you. No further questions.
All right, redirect.
I redirect, Your Honor, may Ms. Park step down.
She may. Plaintiff wishes to present any other evidence?
Yes, Your Honor. The plaintiff calls Mr. Sebastian to stand.
All right.
Good morning, Mr. Sebastian. Would you please introduce yourself to the jury?
Good morning. My name is Jules Sebastian.
And how are you related to today's case?
I'm the lead forensic investigator here at Breckenridge County, Midlands.
I'd like to go into more about what you learned about the case, but I want the jury to understand a little bit more about your background. Can you tell us where you went to school?
I went to school at the University of North Carolina, Charlotte. I got my undergraduate degree in criminal justice. I then went to John Jay College and got a master's degree in the same subject. Then I went to the Midlands Police Academy, where I was certified forensic investigator. I served as an assistant forensic investigator for 12 years before moving up and being promoted to lead for the past 4.
And what exactly did you investigate for today's case?
Well, I was tasked to forensically reconstruct the scene on August 18, 2010.
So how does somebody go about forensically reconstructing a crime scene?
Well, in the police academy, they teach you tons of different tests of how to tell what exactly happened. There are hundreds of tests that we can use I try and use the best tests at my disposal as tools to figure out what exactly happened.
What kinds of facts or data do you look at in order to perform these tests?
Well, the forensic evidence at the scene. Anything can be able.
And were these facts and data sufficient to apply to your tests?
Yes, ma'am. I had all the evidence I needed.
Were you able to reliably apply the training you received to conduct these tests?
I was.
All right, now, I want the jury to get a really clear understanding of exactly what you learned. I know that when you were explaining it to me, you used my co-counsel to set up a demonstration of what you learned. Do you think that would be helpful to do again today?
Of course.
Your Honor, can Mr. Sebastian step down and use my co-counsel to show us what happened?
You may.
If you don't mind, Mr. Walsh and Mr. Bailey. Mr. Walsh will be playing the part of Miss Jessie Duran, and Mr. Bailey will be Sydney Park. If you don't mind standing right here for me, and you about 6 feet away at a right angle. Thank you very much.
Now, how did you know that Jesse and Sydney were about 6 feet away?
From the ballistics testing that I conducted on the
Objection, lack of foundation. If I may respond, Your Honor.
You may.
We haven't heard the specific factors that Mr. Sebastian relied upon today, what facts he collected, what evidence he collected on the scene. In order for him to reconstruct what exactly happened on August 18th, we need to know exactly the evidence he collected. Your Honor, if I may respond.
You may.
At this point, we've laid the foundation that Mr. Sebastian was able to look at sufficient facts and data to reliably come to his conclusions. If opposing counsel wants to go into the specifics of that, then that's something that they can take up on cross-examination. At this point, in order for Mr. Sebastian to tell us his conclusions, we needed to know that he was able to do so reliably with the facts and data that he had, and we have laid that foundation.
Response?
Your Honor, it's not enough for Mr. Sebastian just to say that he reliably applied any method to the facts that he collected on August 18th. That's not enough for the jury to test the reliability of this method. It doesn't fall under any standard, especially under tarot of case law in today's case. We can't assess any known error rate of any method because we can't apply it to the facts in today's case. Your Honor, if I may respond.
No. So, I think, so he has said that he thinks there's sufficient facts. I don't think he's told the jury what those facts are. So, why don't we hear a little more about these methods, if these methods are commonly relied upon by forensic analysts? Just, let's get a little more background.
Yes, Your Honor. Mr. Sebastian, if you could step down, I could ask you a few more questions.
He can just stand there, it's fine.
Okay. Were the tests you conducted things that you learned about in your training in police academy?
Yes, of course. All the tests that I conducted are reliably applied to cases all over Midlands and all around the country and all around the world. I've been doing so for decades.
Were you able to apply the same standards in today's case?
Yes, of course. We have better technology than they did in the 50s, but all of these tests have been reliably applied to criminal cases, civil cases, any sort of investigation that the police department conducts. These are the kinds of tests that they use.
And were the facts and data that you conducted that you obtained from the crime scene sufficient to be able to apply those standards?
Yes, they were.
Thank you. Objection, Your Honor. At this time, we still haven't heard the exact evidence he collected and what he relied upon for his interpretation of what happened. Your Honor, if I may respond.
You may.
Mr. Sebastian told us that he was able to follow police protocol and the standards he learned from the police academy. Anything more specific than that does not necessarily need to be gone into in order for Mr. Sebastian to tell us his conclusions.
Well, I think it's helpful for the jury to know, did he find hair? Did he find footprints? Did he find a gun? So can you just ask him, like, what physical evidence he collected at the scene?
Sure, Your Honor.
Okay.
Mr. Sebastian, what was the physical evidence that you were able to get from the scene?
Well, to set up the 6 feet apart, what I used was ballistics testing from the
Objection,
weapon
lack
that I
of
conducted.
foundation as to the fact that they were 6 feet apart. Before he can come to that conclusion, he needs to state
Okay,
procedures and evidence.
Stricken. Sustained.
Mr. Sebastian, could you tell us what you were able to collect from the crime scene?
I was able to collect ballistics testing. I was able to collect fingerprints. I was able to collect gunshot primer residue tests. I was able to view the positioning of the body. I was able to look at blood spatter analysis. I was able to analyze the wound itself at the autopsy. I was able to get all the angles necessary. I was able to look at the soot and stippling on Sydney Park's face, body, to figure out how far apart they were. I had access to all the information in the scene. And
So could you tell us what from that told you that Jesse and Sydney were 6 feet apart?
Well, as I was saying earlier about the ballistics test, what I did was I looked at the patterns of the burns on Sydney's face from the soot and stipple, and I compared it to the patterns in ballistics tests that I conducted on the same weapon. From that test, I was able to know that the gun was fired from 6 feet away from Sydney's face.
Did you know anything about what might have happened prior to the moment of the shooting from what you were able to see?
I did. From fingerprints I lifted off the bullet, I was able to tell that Jesse Duran loaded that gun.
Objection. Lack of foundation to the procedure of comparing fingerprints. We need to hear the exact procedure associated with fingerprint comparisons in order for him to come to any conclusions of any matches today. Your Honor, may I respond?
You may.
Under Rule 703, Mr. Sebastian is allowed to go into his conclusions without going to every specific step in his training that he learned from the police academy. He can tell us his conclusion because we know that he was reliably applying what he learned from that academy, and that the facts and data we went into earlier were sufficient for him to do so. Opposing counsel is going to welcome under cross-examination to specifically talk about what his training taught him, but that's not necessary for us to go into those conclusions right now. Your Honor, if I may be heard?
No. So here's the deal. There is a middle ground here. He cannot just say that he, found a fingerprint and just knew who it belonged to. You need to tell us he did fingerprint testing. There are points of comparison. He matched. That's enough for 702. If you have additional questions about that method, once he kind of lays that baseline, that's what cross-examination is.
Yes, Your Honor.
Okay. So there's a middle ground, and that's where we need to be.
Yes, Your Honor. So, Mr. Sebastian, what did you do with the fingerprints you collected to tell us that, to find out that Jesse Duran loaded the gun?
Well, after I lifted the fingerprints from the shell casing, I compared it to all the fingerprints that I lifted from everyone at the scene. They matched closely with Jesse Duran's fingerprints. That's how I was able to identify that Jesse Duran was in fact the one who loaded that gun.
Could it have been possible that Sydney loaded the gun?
No, the fingerprints on the shell casing were entirely inconsistent with Sydney Park's match.
All right, well, what about anyone else that might have had access to the gun? How do we know that Andy Park may not have loaded the gun?
Well, I actually tested Andy Park's fingerprints specifically, but other than that, all bullets in the United States are sold sealed as a matter of federal regulation. So it's unlikely that anyone else could have had access to put fingerprints on that bullet.
So what do we know about what Jesse looked like at the moment of the shooting?
Well, from the gunshot primer residue that I conducted, what happens with gunshot primer residue, if you don't mind holding out your arm actually, when someone fires a gun, gunshot primer residue comes out the back and sprays all over the shooter's hands, arms, chest, and the rest of their body. From this, I can identify how far away from the shooter itself the gun was fired, and in what position their body may have been in. From this primer residue testing, I was able to tell that Jesse Duran fired the weapon at Sydney Park's head far away from her body.
What would the gunshot residue have looked like if Jesse may have caught the gun instead of holding it out outstretched
Well,
like
if
this?
you don't mind raising your other hand, if Jesse Duran had caught the gun with both hands, I would see identical concentrations on her right and left hand, as well as identical gradients all the way down her arms, with lower amounts on her chest.
What would the evidence have looked like if the gun was maybe closer to Jesse's chest?
Well, if the gun was closer to Jesse's chest, I would have seen identical concentrations on both of her hands and around pretty much all of her clothes. But this is not what I found. What I found was a high concentration on her right arm, an unbroken gradient down her clothes, and a lower concentration on her left hand.
All right, so what do we know about how Sydney looked at the moment of the shooting?
Well, from the blood spatter analysis that I conducted, due to the wide sweeping arcs of the bleeding, I can tell that Sydney was moving her head rapidly as she was shot. Because of the entry wound, I was able to identify that Sydney Park was not looking at Jesse Duran as he shot her.
And what about the wound told you that Sydney was not looking?
Well, because it went in at an ellipse, which means that the bullet hole itself was elliptic as opposed to a circle, which means that it didn't go in straight on. It went in at an angle. Those wide sweeping arcs in the blood splatter, too, were able to tell me that Sydney was moving her head rapidly as she was shot. If it went in at an angle and she was moving her head rapidly, her head must have started further away from the gun. I identified it to have started at approximately right angle.
what were you able to learn happened after Jesse Duran took the shot?
Well, when Jesse Duran pulled the trigger on the gun, the bullet would have flown through the air towards Sydney Park. She would have started to turn her head rapidly, and the bullet would have struck her directly above her left eye, leaving that elliptical hole. The momentum would have carried her off the couch and onto the ground to her final resting place in a pool of her own blood.
So now that we know exactly how you came to these conclusions, could you show us exactly what you learned the moment of the shooting looked like?
Well, after Miss Duran would have loaded the gun, she would have raised her right hand up, pointed at Sydney Park's head, fired. Sydney would have rapidly turned her head. The bullet would have come, struck her directly above the left eye. The momentum would have taken her off the couch and onto the floor, lying on her right side, in between the couch and the coffee table, which is exactly where I found her.
Is this how Sydney looked when you found her?
Yes.
Thank you, Mr. Sebastian. No further questions at this time.
All right, cross-examination.
Yes, Joe. May I proceed? Mr. Sebastian, I have a couple of questions of that reconstruction that you just provided for us.
No problem.
Starting with the evidence that you relied upon.
Okay.
Now, you received a phone call for Officer Dale Williams around 10:06, right?
Yes, that's when I was dispatched to the crime scene.
And that was about already 20 minutes after the accident actually occurred.
Yes, from time of death, it'll be attributed to the autopsy. That was about 20 minutes afterwards. You're correct.
So by the time that you received the phone call and the time that you actually arrived at the crime scene, it was another 20 minutes.
Yes, I was actually able to get to the crime scene in 40 minutes, which is quite quickly for a forensic investigator like myself.
All right, so Mr. Sebastian, by the time that you arrived there, 40 minutes had already lapsed since the accident occurred.
Yes, it was 40 minutes. Sometimes it can take up to 3 hours, though. I'm glad I was able to get there so quickly.
Now, you know that the officer in charge is supposed to preserve the crime scene.
Yes, and from all indications and everything I looked at, Dale Williams did a great job.
Well, that's standard protocol for Dale Williams to preserve each aspect of that crime scene.
Yes, he's the only person there, and so he's the only person who can make sure it gets done. However, there are telltale signs in the evidence where I can tell if it's been contaminated.
Well, things that he had to look out for were GSR, right?
Gunshot primer residue, yes.
He had to preserve any particles of GSR right away.
Well, ideally, yes. And whether he did or not, that GSR, those gradients I was talking about earlier, were unbroken. And therefore, he must have done a great job.
But it is ideal to preserve them right away.
Ideally, yes. But what he did, whatever he did, was sufficient.
Now, Officer Williams is trained as a detective to preserve the crime scene, right?
Officer Williams is not a detective man, but yes, he was trained.
As a police officer who is supposed to preserve a crime scene for your investigation, he is trained to do the minor steps, right?
Yes, and he did a great job.
Because that's the evidence that you rely on.
Exactly. It's very important that I have all the evidence that I can rely on.
That's the evidence that you testified to today.
Right, exactly. And from all the looking I did it to see if the evidence was contaminated, it was not.
And whether or not the evidence was contaminated would really rely upon what Officer Williams did on August 18th.
Right, exactly. And I was able to look at the evidence and see none of those telltale signs of contamination, and that's how I know he did a great job.
Now, specifically talking about the GSR that you mentioned on direct examination, you know that GSR has its flaws.
It can be delicate, and if proper steps aren't taken, it's possible that you can break those gradients, but I saw identical, nice, smooth gradients along Sydney's and Jesse's clothes.
Well, not only can these gradients be broken, but GSR can certainly be transferred from person to person.
Right, and that can mess up those gradients.
It's easily transferred.
Yes, if through hard and firm contact, you're definitely correct.
And you know that certain things, certain factors actually hold a lot of GSR to begin with.
Yes, I know cop cars can have GSR in them.
Let's talk about everything that could potentially have a lot of GSR particles on them. One of these things are police officers.
Yes, police officers, if they make hard and firm contact with the surface, they can break those concentration gradients.
Another factor would be the back of a police officer's car.
Yes, so the back of a cop car, if you brush up against it, could certainly break some of those gradients.
And another factor would be the police station itself.
Yes, those can contact with a lot of surfaces inside a police station can break those concentrations of gun primer residue.
So, Mr. Sebastian, you don't actually have to be the shooter to have GSR particles on you.
To have particles on you, you're correct.
So if a police officer theoretically were to touch Jesse Duran, that could affect any particles on Jesse Duran.
Yes, in that one spot, you're definitely correct.
Now, the GSR that you found on August 18th, you testified to, was on Jesse Duran's right hand, right?
Yes, as well as on her clothes and left hand as well.
Now, Mr. Sebastian, you testified that when GSR leaves the barrel of a gun, it flies backwards around your immediate surrounding, right?
Yes, onto the hand, arms, and body of the shooter.
Well, it's not only confined to the body, it's confined to the surrounding areas, right?
Well, usually most of it lands on the body because it's directly in front of you and it sprays out onto your chest, arms, and hands.
But it's also around the space where that gun was fired.
It's certainly possible that GSR particles could land on something that wasn't the shooter.
Now, you believe that Jesse Duran was sitting in the tan armchair on August 18th when that gun was fired.
That's certainly correct.
You found no GSR particles on that tan armchair, did you?
No, I found them on Jesse Duran.
And none on the thing that you thought he was sitting on.
Right, that all the GSR particles landed on the shooter himself.
So you found no GSR particles on the object you believe Jesse Duran was sitting on while she shot the gun.
That's not atypical, ma'am.
Now, Mr. Sebastian, you also stated that you believe Jesse Duran loaded that gun.
I do.
And you believe this because you did fingerprint analysis.
That's true.
Now let's talk about the actual procedure of fingerprint analysis.
No problem.
There's no universal standard for this analysis, is there?
I wouldn't exactly characterize it like that.
Well, in your field, there's no agreed upon standard of comparison.
Well, there's an agreed upon standard of comparison. There's no agreed upon standard of how many points you need to match.
Well, you use the 16-point standard,
Typically for criminal cases.
and that's what you determine is a full match.
Yes, that would be a full match in an ideal world. I would have 16-point matches on everything.
Now, that's a standard that you use, Mr. Sebastian.
Yes, I've certainly used it before.
You use it quite frequently.
Yes, it's what I like to use, and if I can, I'd like to apply it.
So only if you can do apply the standard.
I mean, how if I couldn't apply the standard, how would I apply it?
Well, Mr. Sebastian, are you telling me that otherwise you change your standard to fit the facts that you found in a case?
I don't change my standard, ma'am. I just can only apply my standard where it's applicable.
Well, today you testified that Jesse Duran loaded the gun because you found fingerprints on the capsule of the bullet.
Right. I know Jesse Duran loaded it because no one else could have loaded it.
Well, all you found on that capsule was a 10-point match.
And a 12-point match.
So a 10 and a 12-point match, well below your 16-point standard.
They were on the same hand, in the thumb and index finger. They were both partial prints, and so a 16-point match was completely out of the question. There weren't even 16 loci to look at. However, I was able to look at everyone else at the crime scene, and they were all 0-point matches for those fingerprints. That's how I know Jesse Duran loaded the gun.
Well, Mr. Sebastian, let's break that up. It wasn't a 16-point match.
No, it wasn't.
You only found 10 points
Yes.
and 12 points.
Yes, I was able to find 2 fingerprints on the bullet.
And this was a partial print.
Both of them were partial prints, yes.
Now, you didn't test Officer Dale Williams for fingerprints that morning.
No, I didn't. We have Officer Williams' fingerprints on file.
You didn't test any of the EMTs that morning that were on the scene.
No, the EMTs didn't touch the gun.
Well, you weren't there, were you?
The EMTs that touched the gun, that would be a gross deviation from protocol.
While it would be a deviation from protocol, you weren't there,
I was not.
so you don't know what happened.
Sure.
No further questions.
Redirect.
proved adequately.
No, and like I said, there are telltale signs that we can look at to see if the evidence was not observed, especially with gunshot primer residue.
All right, now I want to clear up a little bit of what you talked about earlier in terms of the partial prints. First of all, could you tell us what a partial print is?
I actually teach classes on this at the academy. I like to show the jury a little something circular because that's the most common way you find partial prints. Do you mind if I show them?
Your Honor, could Mr. Sebastian step down and use a pen to show us what he knows about partial prints?
Any objection?
Yes, Your Honor, to 403, substantially misleading to qualify a pen as being the same thing as a bullet. Your Honor, can I respond?
You may.
Mr. Sebastian just told us he just needs something circular to show us how a fingerprint might look on something that is shaped like a bullet might. This is clearly probative. Opposing counsel has asked a lot of questions about the fingerprints on that bullet. In order for the jury to understand exactly why the fingerprints may have looked the way that they did, it's going to be very beneficial for Mr. Sebastian to show us how Jesse Duran's fingers might have been holding the bullet, and therefore why the fingerprints may have looked the way that they did. If I may respond, Your Honor?
You may.
A bullet is, especially in this case, we don't know how thick the bullet was, what it looked like. Comparing a bullet to a pen would substantially mislead the jury into believing that it's difficult, potentially, to actually put a print on the bullet. In today's case, that is part of their burden, and that would be substantially misleading under 403.
Response?
Yes, Your Honor. Mr. Sebastian just told us that what's similar between the bullet and the pen was the shape, not necessarily the thickness. We're not trying to make the claim that this pen is going to look exactly like a bullet. We just want to show the jury this one factor to help them better understand what just happened on this cross-examination. Any other factors that opposing counsel believes might confuse the jury can certainly be cleared up on a recross, but we're not trying to mislead the jury into looking at other factors that are not relevant. Your Honor, if I may respond briefly?
Yes.
They can talk about any comparison without actually using a demonstration. That would mislead the jury. Talking about how difficult it may be, he certainly can do that without demonstration. Your Honor, if I may respond.
No. I'm going to overrule your objection, but you're more than welcome to recross on it.
Mr. Sebastian, go ahead and step down. Could you tell us what you were talking about?
Well, the bullet used was a 9mm bullet. It was a 9mm revolver. This pen right here is about that size. It's circular and it's small. And when I grip it, you can see only the middle of my finger actually touches the bullet itself. And therefore, on bullets, it's very uncommon that we get full fingerprints. That's why we usually use partial prints to rule out anyone else before we can make a claim as to who loaded any guns.
No further questions, Your Honor.
All right, any recross?
Yes, Your Honor. If I may borrow the pen. Mr. Sebastian, if I'm holding this pen right now, you're not testing it for fingerprints, are you?
Not the pen, no, but if it were a bullet at a crime scene, I would.
Well, you certainly aren't testing it right now.
No.
So you don't know if my fingerprints right now are on this pen.
I actually can if I could look at it more closely.
Well, you're not testing it.
Well, I could.
So if I hold the pen like this and move my fingers around this pen, it could have my fingerprints on it.
It certainly could, although when you're loading a bullet, typically you don't roll them to make sure that your fingers leave a full print.
Well, typically you don't, but you weren't there on August 18th.
No, I just have access to the forensic evidence that told me what I know.
You weren't there when somebody had touched the bullet.
I wasn't there when Jessie Duran left her prints on the bullet, no.
Well, you weren't there when whoever touched that bullet held it.
No, I wasn't. I just know the markings that were left on the bullet, and the markings that were left on the bullet were consistent with Jessie Duran's fingers.
So you don't know exactly how that person touched and held that bullet.
Well, I know that Jessie Duran had her thumb and index finger on the top and bottom of the bullet, which is consistent with the fingerprints that I found.
And once again, you weren't there, so you don't know if anyone else could have touched that bullet that you didn't test.
If someone had touched the bullet and left absolutely no fingerprints of any kind and didn't smear the ones that were already there, I wouldn't be able to tell you that, no, ma'am.
But it's a possibility.
Not really, no. It's highly unlikely.
Mr. Sebastian, you weren't there, so you can't be 100% sure.
Forensic testing allows me to show a degree of certainty about what I know for things that I was not there for. I was not there when Jesse Duran touched the bullet, but I can tell you that Jesse Duran did.
But you didn't test multiple other people at the scene, and you don't know how Jesse Duran or anyone else was holding that bullet on August 18th.
I do know how Jesse Duran held the bullet on August 18th. Like I told you, it was in between her right thumb and right index finger.
But if someone else had held it, you don't know how exactly that was.
If someone else had held it, in addition to Jesse Duran, without smearing her fingerprints, I couldn't tell you that, but that's highly unlikely, ma'am.
No further questions.
All right, we redirect.
No, Your Honor. Yes, but Mr. Sebastian, do you allow to step down?
Amen. Mr. Walsh?
Your Honor, before we begin the direct examination, could we have a little time to set up the demonstrative and the welcome?
Yes. Ms. Hogan, you're free to move.
Thank you, Your Honor.
Your Honor, at this time, the plaintiff calls Dr. Couples to the stand.
All right.
Your Honor, may I proceed?
You may.
Good morning, Dr. Couples.
Good morning.
Could you please introduce yourself to the jury?
Hi there, I'm Emerson Couples.
Dr. Couples, what do you do for a living?
I'm an associate professor of psychology at the University of Iowa.
Where did you get your education from?
I got my undergraduate degree in psychology from McAllister College. I then went to the University of Illinois, where I got my master's and PhD in psychology.
Where does your research focus on at the University of Iowa?
I'm a specialist in child psychology. I focus on research in a series of behavioral disorders called disruptive behavioral disorders. They range anywhere from bipolar disorders, attention disorders, all the way to psychopathy.
Dr. Couples, I actually want to talk about psychopathy here for a little bit. Could you tell the jury a little bit about what psychopathy is?
Sure. Psychopathy is a condition characterized by intense egocentrism. Patients who have psychopathy exhibit a lack of impulse control, as well as a lack of empathy.
Why are you here in today's case?
I was asked to analyze Mr. Rand's psychological state, and I'm here to talk about that.
Dr. Couples, what sort of information do you need in order to analyze Mr. Rand's mental state?
I need information that helps me set up a psychological profile for Mr. Rand, which I can then conduct tests on. I look at facts about behaviors that Mr. Rand may have acted out, any things that she may have done in the past. I interview people, and I look at other sworn statements in this case.
Well, specifically, what information did you have access to in this case?
I had access to the sworn statements of Mr. Rand's mother and Sydney Park's mother. I also had the affidavit of Terry Chapin, who was an individual who was at the scene of the crime. I also conducted personal interviews of Jesse Duran's teachers, her classmates, some of her friends, as well as her babysitters.
And now, you mentioned that you tested Ms. Durant to evaluate her mental state. What sort of tests did you run?
I conducted a test known as the PIJ. That stands for the Psychopathy Assessment Instrument Juvenile. It's the test used standardly to assess psychopathy in minors.
How do you know that the PIJ test is a reliable test to apply to observe Ms. Durant's mental state?
It's been used for years in the psychological community. It's been subject to peer review and experimentation, so I know it's very reliable.
Now, did you get a chance to interview Ms. Durant in order to form your conclusions?
I tried to, but I was not allowed to by her attorneys.
Well, even though you were not allowed to interview Ms. Durant herself by her attorneys, did you have enough information to conduct this test in a sufficient manner?
I did. The information that I gathered was sufficient for me to create a psychological profile of Ms. Duran.
Objection, Your Honor. Lack of foundation, if I could explain.
Yes.
Now, opposing counsel asked the witness if the PIOJ test was reliable under the way that he used it, but we haven't heard specifically about what age range that was supposed to be used for, whether or not it was supposed to be relied to a child as young as Jesse. You know, I could actually make an offer of proof.
Well, you can either voir dire or save it for cross.
I would be happy to voir dire the witness, Your Honor.
Go for it.
Good afternoon, Dr. Couples. Now, you use a PAIJ test when testing Jesse Duran for instances of psychopathy, is that correct?
Yes.
That PAIJ test is used to diagnose people with psychopathy.
It's used to diagnose minors.
And it was actually designed to be used to diagnose minors between the ages of 12 and 16, is that correct?
You're right. It was initially designed for individuals between 12 and 16 years of age. However, through peer review and scientific experimentation, it is now used to test all minors.
Dr. Couples, I'm not asking how you used it. I'm asking how it was originally designed. And that was for people between the ages of 12 and 16.
Yeah, back in the 1970s, when they initially designed it, that was the purpose. Today, this is what I use it for.
What you use it for, and you used it on Jessie when she was only 11.
As the rest of the psychological community today would do. You're right.
Your Honor, I would at this time end my voir dire and say that because this test was not used effectively the way it was designed, Dr. Couples should not be testifying to it on Jesse Duran.
Your Honor, Dr. Couples told us that the test was originally designed to test minors between the ages of 12 to 16 back in the 1970s. However, when opposing counsel was asking him questions about whether or not this test was reliably used in the psychological community, he told us that now, throughout the psychological community, it is used to test on minors of all ages. Your Honor, he testified that he had enough information to reach his conclusions. Any further inquiry goes to weight, not admissibility at this point, Your Honor.
Yes, based on what he said on your voir dire, other people are using it that way, so I think it's fine. You're welcome to revisit the issue on cross if you want.
Yes, Your Honor.
Your Honor, may we assume that the jury's been let back into the room after the voir dire has taken place?
Yes.
Dr. Couples, were you able to reach your conclusions to a reasonable degree of medical certainty?
I was.
Well, Dr. Couples, while you were talking to me about this test that you used, you had a chart that listed the different items you were looking for in Jesse Duran. Do you think it would be helpful if we showed that to the jury?
I sure do.
Your Honor, could Dr. Couples step down to use his chart?
Yes.
Dr. Couples, why don't you step down over here? And could you explain to us a little bit about what we're looking at?
Sure. This is a list of the scores of the different traits the PIJ looks for. Think about what happens when you go to the doctor when you're sick. The doctor looks at your symptoms. If you have a fever, if you have nausea, if you're sneezing and coughing, the doctor might look at your symptoms and diagnose you with the flu. In the same way, the PIJ test looks at symptoms within your psychological profile and uses them to assess whether or not you have a score that is sufficient to determine whether you have psychopathy or not.
What are these numbers down to the side next to these different traits?
They're the scores that I score the traits for. The lowest score possible is a 0, and the highest score possible is a 2.
I want to talk about these traits. Could you tell us why you gave Jesse Duran a 0 for early sexual experimentation and cutting class or missing curfew?
A score of 0 means that no evidence of that particular trait was present. I found no evidence that Ms. Duran had engaged in early sexual experimentation or that she had ever cut class. So I scored that trait a 0.
What about those traits marked with a 1?
Well, in order to score a 1 on these symptoms, you have to show a general prevalence of that specific symptom. I found some evidence that Ms. Duran had engaged in petty theft from her classmates and her teachers, and these other symptoms were also shown to some evidence.
Dr. Couples, I want to focus on these top 4 traits: persistent aggression, gratuitous or guiltless lying, unresponsive to reprimands, and defiance of authority figures. Why did you mark these 4 items as a 2 when you were evaluating Ms. Duran's psychological state?
In order to score a 2 on a PIJ test, you have to show a strong history of those traits. And I found that in Ms. Duran.
All right, Dr. Couples, you can take your seat now. I want to go into just specifically how much evidence is required in order to diagnose somebody with a 2. Now, what did you have access to? Let's take persistent aggression as an example. What did you have access to tell us that Miss Durant was a persistently aggressive child?
I had access to a school discipline notification about Miss Duran's activity in which she beat up some of her classmates.
Would you recognize this discipline notification if I showed it to you?
Sure.
Your Honor, I'm showing opposing counsel a copy of this discipline notification.
Which part were you referring to?
The whole document.
Would you like to that?
No, you can't. It's a copy for you. Dr. Couples, I'm handing you a copy of that discipline notification. Could you identify it for us?
Yes, it's a discipline notification we were just talking about.
Is that a true and correct copy of that discipline notification?
It is.
Does it appear to be changed, altered, or modified in any way?
Not that I can see.
Your Honor, we offer Exhibit 1 into evidence.
Objection to hearsay, Your Honor.
All right.
Your Honor, pursuant to Rule 703, this is evidence that Dr. Couples relied upon in order to determine his medical conclusion about Miss Durant's state of mind. As a result, whether or not it's admissible is irrelevant in this case, as long as we show that it's substantially more probative than it is prejudicial.
Is that a fair reading of 703?
No, Your Honor, I don't believe it is. Now, what Rule 703 does is allow experts to come to conclusions based on evidence that may otherwise be inadmissible, but that doesn't open the floodgates for the jury to be able to review any otherwise inadmissible evidence that they see fit. Now, opposing counsel would be offering this document to prove the truth of the matter asserted, that these instances within the document did actually happen. Under Rule 703, Dr. Couples may rely upon it to come to his own conclusion, but to enter this document into evidence and allow the jury to review it isn't what Rule 703 was trying to protect.
Response?
Your Honor, we're not trying to use Dr. Couples as a conduit to hearsay that is outside of his expertise. Your Honor, he relied upon this document, and based on 703, it's admissible.
So, if he's not being a conduit to hearsay, then what's the value added that he's adding to that document?
Your
Was
Honor-
he there when the incident happened?
Your Honor, but he was
Did he
not.
interview those people? What's the value added? Why is he not a conduit?
Well, Your Honor, he did actually interview those people. As he told us earlier, he interviewed teachers and classmates. As to the probative value of this being entered into evidence, Dr. Couples is making a substantial claim here about Ms. Durant's mental state. And we want the jury to get to know exactly just how much evidence it takes in order to convince a trained psychologist that Jessie Durant was indeed diagnosed with psychopathy.
Your Honor, if I may.
Please.
Dr. Couples can certainly testify to whatever relevant factors he saw fit in diagnosing Jessie Durant with psychopathy. However, to enter this document into evidence in its entirety is hearsay. It's offering nothing but to prove the truth of the matter asserted. Dr. Couples could come to the same conclusion that he did without entering this document for the jury to be able to review.
Yeah, I think he's more than welcome to testify to his conclusions, but the document's not going to be.
Yes, Your Honor. Your Honor, can I go get that back from Dr. Couples? Dr. Couples, did you have access to any other information that demonstrated to you a trait of persistent aggression?
Absolutely. I also emailed an email that Mr. Duran wrote to one of his friends.
Would you recognize a copy of this email if I showed it to you?
I would.
I'm approaching opposing counsel with a copy of this email. Dr. Couples, could you identify what I just handed you?
Yes, that's the email we were talking about that Mr. Duran's father, Hayden Duran, sent to one of his friends.
Dr. Couples, is that a true and correct copy of that email as you reviewed it?
Yes, it is.
Does it appear to be changed, altered, or modified in any way?
Not that I can see.
Your Honor, at this point, we offer Exhibit 2 into evidence.
Your Honor, I would object to this being substantially more prejudicial than probative under case law Wyatt v. Alley.
Okay,
That's on page 2 of your case law.
excellent.
If I could explain,
Please.
Wyatt v. Alley states that using prior bad acts of a defendant to support liability does nothing, there's no probative value to it, and actually creates a substantial danger of confusing the facts under Midland's Rule of Evidence, Rule 403. Now, what's contained within this email are prior bad acts of Jessie Duran that opposing counsel will try to elicit, and this case law clearly states that to support liability, you can't do that.
Response, is that a fair reading of that case?
Your Honor, it's a fair reading of the case, but is opposing counsel objecting to the fact that this drawing is in fact a prior bad act?
Oh, Your Honor, I'm referring to the email, actually,
Right.
and the
Is there-
contents
what are we-
within it.
I thought you offered an email into evidence.
Excuse me, Your Honor. Yes. Your Honor, once again, this falls under 703. This is information he
Wait a
relied
minute.
on.
what's your objections like hearsay though, right?
It's just substantially more prejudicial than probative, Your Honor.
Your Honor, 703 is not limited to just hearsay. It is any otherwise inadmissible
No,
evidence.
but she's not objecting under 703, she's objecting under 403.
Your Honor, I'm responding with 703. 703 allows us to go into any otherwise inadmissible evidence barred by other rules in the Midlands Rules of Evidence. If you take a look at Rule 703,
Okay, I'm gonna stop you there. So she's saying it's substantially more prejudicial than probative. You're basically saying that it's substantially more probative than prejudicial. And I would like you to explain to me why one of those things is true.
Your Honor, we want to Your Honor, we want to demonstrate just specifically what Ms. Durant's mental state was on August 18th and leading up to the shooting. That is the probative value that goes toward this.
Okay.
Your Honor, this case law states that a prior bad act, such as one that could be elicited from this email, is not available to be used to prove liability in today's case. This case law clearly states that there is no probative value to hearing the prior bad acts of a defendant, and that all it does is confuse the issues under Rule 403.
Response.
Your Honor, we're not trying to confuse the issues. Dr. Couples is coming up here and he's offering us a medical conclusion. This is information he relied upon in the formation of that conclusion. Because of that, Your Honor, we want the jury to get an idea of just what kinds of information he relied upon and the specific information he had access to and that he reviewed in forming his conclusions. That's the probative value in today's case.
So if what you just said is true, then can't he just say, I read an email and based on that email, I came to a conclusion?
Your Honor, he can certainly say that, but under Rule 7.3, we're allowed to go into specifically what information he relied upon, even if it is otherwise inadmissible.
Last argument.
Yes, Your Honor. The fact is that opposing counsel is using this prior bad act contained within this email to support liability of Jesse Duran in case law Wyatt v. Alley says specifically that that only goes to confuse the issue under Rule 403 and that there is no probative value to it.
Let me read this case. Okay. I think this is a close call. I'm gonna let it in. You are more than welcome to cross-examine on the context through which he obtained the email and who we talked to and blah, blah, blah. But I'll let it in.
Yes, Your Honor. Dr. Couples, what in that email indicated to you that Jesse Duran had a trait of persistent aggression?
Well, David Duran emailed his friend saying that the other parents had told him that his daughter was pointing sticks at their children and saying things like, bang, you're dead, pretending to shoot him that way.
Did you have any other examples of Mr. Duran conducting these mock shootings?
I did. When I looked at the sworn statement of the babysitter of Sydney Park and Jesse Duran, I read evidence that Miss Duran had told Sydney, I want to shoot you, you're going to die.
Your Honor, could I approach, Dr. Couples, I'll take that back. Thank you. What other evidence did you have access to in order to demonstrate that Jesse Duran had a trait of persistent aggression?
I looked at a drawing that Miss Duran had made in school that depicted her using a gun.
Approaching opposing counsel with a copy of this drawing. Dr. Couples, could you identify what I'm handing to you?
Yes, it's that drawing that we were just talking about.
Is that a fair and accurate representation of that drawing?
Yes, it is. It's an exact copy.
Does it appear to be changed, altered, or modified in any way?
No.
Your Honor, at this time, we offer plaintiffs tuned evidence.
Your Honor, I would object to this document being substantially more prejudicial than it is probative.
Your Honor, I have a feeling we're about to go through the same thing that we just went through. Your Honor, under Rule 703, this is something he relied upon in the formation of his conclusions, and you just ruled on the admissibility of the prior document.
Well, so, wait a minute. No. That was an email sent by that parent. This is a drawing made by a child. So
Yes, Your Honor.
they're very different. And we haven't even heard the grounds for her 403. Is it the same argument or a different argument?
It's a different argument, Your Honor.
Okay.
My apologies, Your Honor.
Your Honor, this document is substantially more prejudicial than it is probative, and that we haven't heard any context as to when this drawing was created, under what circumstances it was created, how old Jessie Durand was when this cartoon was made. Now, there's no probative value for the jury to just look at a cartoon that a child drew and to say that this was created as a violent, aggressive tendency used to diagnose psychopathy in today's case.
Your Honor, it's not up to the jury to determine whether or not this document provides such a diagnosis. That's Dr. Couples' field of expertise. That's why he's testifying. It's because he provides that technical background that we may not have available if we had another lay witness up here on the stand. Your Honor, this document is something that he reviewed that was drawn by Jessie Durand. We can lay a little bit more foundation about the context of this drawing if you would like, but Your Honor, this is information he relied upon.
Okay. I'm going to let it in, but you are more than welcome to raise all of those concerns with him on cross-examination.
Yes,
because
Your Honor.
ultimately, he read that, and he's going to come to whatever conclusions that he came to based on that, and you're more than welcome to delve into those.
Yes, Your Honor.
Dr. Couples, what about that drawing indicated to you that Jessie Durand had a trait of persistent aggression?
A couple of different things. The last pane of the drawing shows him write the phrase, "I heart my gun," saying that that she likes the gun. On top of that, the previous pane shows Miss Durand pointing the gun at children and saying that she wants to use the gun to scare the children away. That indicated persistent aggression.
Dr. Couples, after you reviewed all of the evidence you had available to you, what was your final conclusion about Jessie Durand?
After I reviewed all of those pieces of evidence I could look at, I added up the score and I got a total score of 12. That was enough for me to medically diagnose Miss Durand with psychopathy.
Your Honor, I have no further questions for Dr. Couples at this time. I'd like to publish Exhibits 1 and 2 to the jury.
Great.
Okay.
Yes, Your Honor.
Would opposing counsel like me to take down the demonstrative?
Oh, no, you can leave it up. Thank you. Good afternoon, Dr. Couples.
Good afternoon.
Now, you told us on direct examination about the PAIJ test that you used to diagnose Jessie Durand.
I did.
And you told us that you thought that it was okay to use to diagnose someone under 12 with that test.
It's a standard test used for my